don't care what Doug has to say, like it's black and white in this video that it's Doug's fault, and they can give a directed verdict. Okay, if there isn't that much evidence, then basically Doug is going to have the opportunity to defend his situation and present his evidence. So now his lawyer is going to come forward and himself, and he's going to say, hey, these are the reasons that I'm not at fault. Please listen to those, and we'll continue on with this. And the trial is going to continue, and Doug's lawyer has the opportunity to call the same witnesses as Pete's did and ask them questions, and then Pete's lawyer can then cross-examine them as well. So this process kind of goes back and forth throughout the trial. Slide 18 basically just goes over what I already said. So then once we have seen all the witnesses and covered all the evidence, and all the parties have asked all the questions, and we've gone back and forth, we're going to have trial closing arguments. So these are like the punchlines. Everything that we did in the trial up to this point builds up for this blunt, like, sell-all statement that's like, hey, these are the things that I showed you, and this is why I'm right. So everything that we did is to get to this point and know that we have showed the judge and the jury everything that we have, and that we're definitely right, and now we're going to tell them we're right, and we showed you this, and we told you that, and this is all real. Okay? So the jury is given special instructions, obviously, throughout the trial. We see mistrials occur when the jury violates these instructions. But basically, hey, you have to not talk about this court case while you're out on break. Like, you have to pay attention. You have to basically, and they all have to get on the same page. So the jury instructions will be given to the jury by the judge, so that they understand exactly what their role is, and that they follow it so that there isn't a mistrial. We're on chapter 21. All right, so now we're to the verdict. So the jury has gone out, if there is one, and decided what they found. If there isn't one, then the judge has found what he's come to the conclusion of, and now we're at the verdict. So the verdict is essentially the result of all of this process, and the verdict is basically the law binding result of the trial. So finding is the same verdict basically when the judge does it, but once a verdict is given, the judge is basically going to say, hey, this is what happened, this is the result. Doug is going to have to pay Pete the amount of money that he requested in the complaint, and once the verdict is given, it's kind of final, except Doug is then given the opportunity. You can immediately challenge the verdict. If that challenge that happens right then fails, which obviously if they've come to that conclusion, it's really not that likely that the challenge is going to go through, but you have the ability to do it. You can appeal it to the next level of court. So you can say, this court, small, I don't believe that the result that they found is correct, so I'm going to take it up the chain to the next level of court. Now we're going to do this all over again, except in the appeals level, you have to be able to prove that there was a mistake made in the trial, or that there's new evidence, or it's harder to overturn the case up as it goes up each level of appeals as it is to win it right at the beginning. So because then as it goes up the tiers of the different levels of courts, there is no they have to say, well, if we're going to overturn this decision, we're basically saying that the two courts underneath us were wrong, and we have to have more evidence to be able to do that at this point. In our scenario, Doug was found liable for the damages. If he wants to appeal the verdict, he becomes the appellant, which is the person who's appealing the case against himself, and then Pete becomes the appellee, and his stance is basically now he's not accusing Doug anymore because Doug was already found liable for that problem, but Pete is now just defending the result of the lower court. So this court decision that was just made, if it's appealed to the higher level court, Pete's only job is to defend his already won victory. So He just has to continue to provide the evidence that he's owed that money. All right, so now we've done all this process to get to our verdict, and we don't have, there is no necessarily, depending on the way it's set up, way to collect this money. Let's say that Doug is a poor man that has an airplane, right? He inherited this airplane from his grandfather, but he doesn't own anything or have anything other than the airplane as far as assets and money, cash. So enforcing judgments can be a very difficult piece of this process. So Doug is now owes Pete $80,000. It's a lot of money. So Pete's like, all right, well, I won my court case. I need to pay for my medical bills and my airplane. Now Doug's going to pay me. Well, you have this judgment from the court that says that Doug has to pay you, but this doesn't necessarily mean that it's going to happen quickly or easily. So there's several different ways that he can get his money. He can garnish Doug's wages with the court judgment, which basically is like garnishing child support. That Doug is going to have so much money taken out of his paycheck every week, and it's going to go straight to Pete. If Doug has a bunch of money in his bank account, he can take the court judgment through the system and garnish the money straight out of his bank account, seize property or real estate. Well, this is all well and good, except if Doug has a $12 an hour job and Pete garnishes his wages, well, he's probably only going to get like $1 an hour. So now you have to wait for Doug to work 80,000 hours for you to get your money. So this can become a real issue if someone doesn't have anything, but it is still a process. Basically, we're on slide 23. Garnish is defined by withholding a certain amount of money of your paycheck and send it directly to the person or institution to whom you owe money until your debt is paid off. So that is the process there. Some states, sheriffs can go and seize assets to take to auction to pay court judgments. All of these things are different state to state, and how they're handled is different state to state. But these are basically the outlines. So you also have to consider, when we look at taking someone to trial, like, well, if I'm going to take this guy to trial for $80,000 and I win, what's the likelihood that I'm going to get that $80,000? Is it even worth going through this process? Like, yeah, this guy's going to get a judgment against him, but if I don't ever see any of the money, like, is it really worth all of that? So we have to kind of weigh that out as well when we look at the full result on the back end and understanding how we are going to get our money from this court case and enforcing the judgments. I mean, if we're suing a company that has 20 aircraft, like, hey, well, if we're suing them for $80,000, well, guess what? If they don't pay us, we're going to go and seize one of those Cessnas and we're going to sell it, right? So there are kind of those ways to look at the process. But like, if someone sued me for $80,000, I just laugh at them. Like, I don't have $80,000 or anything worth anywhere close to $80,000. Like, don't sue me all you want. Like, you're not going to get your money for 20 years. Like, arbitration. So we're on slide 24. Arbitration is an alternative to the courtroom. So the next couple of slides, we're going to talk about ways that if we want to avoid this trial process, now that we've kind of realized kind of how it works and the different pitfalls that can happen, and where we can kind of get caught up in this sort of thing. Arbitration, a common form of avoiding the courtroom, two voluntary types. So let's say that I'm going into business or signing a contract with another company, and we decide in this negotiation process of our partnership or contract that if we have a disagreement throughout the process, instead of you suing me or me suing you, we're going to agree in advance that we're going to take this dispute to arbitration. So that is an option. It's pre-agreed upon that we can't take each other to court ever. It's only going to go to arbitration, which is an alternative to the court. Now, two people can disagree, like Pete and Doug, and they can decide to go to arbitration instead of court. Involuntary arbitration occurs frequently in the government realm, where labor disputes and union problems go to arbitration, where an employee goes to the union and says, I'm not being paid as much as my peer, and blah blah. And instead of that going to court, it may go to arbitration. Arbitration is they're legally binding, just like a court. The other thing about arbitrations is that there's literally no way to appeal it. So if it goes to arbitration and you lose, that's kind of the end of the road. So basically, arbiter is the guy who's going to basically play being the judge, even though he's not a judge, but he is someone experienced in that field, or a lawyer, or maybe a retired judge, potentially. Basically, he's going to look at the case as if it is a case, but it's not actually in court, and going to issue a finding for the case. We also have on side 25 and 26 conciliation and mediation. So these are ways that we can kind of hope to find a resolution without going to court, even though we have basically the pretrial and all those things before to try to find a way to get around going to court. But conciliation and mediation are a little bit different, because conciliators will basically just be the third grade between two parties that are upset with each other. Like if Doug and Pete were friends before this happened, and Doug hit Pete's airplane, and Pete's like, I'm going to sue you, and Doug said, we've been friends for 10 years, and F you, like, I can't believe that you're not going to talk to me, and like basically they get upset with each other to the point that when they're suing each other, they just stop